for the record.
All right, my name is Paul W. Gillman. I live in the Bronx. I'm the spokesperson on drug war issues and cannabis legalization for the Green Party of New York State, GPNY. And I'd like to thank the panel for letting us speak. Okay, marijuana is being legalized in the United States, including New York. It's almost a done deal. That is what these hearings are all about. The question is, who will control it? Will we here in New York allow big tobacco, alcohol manufacturers, the pharmaceutical companies, the Monsanto-style monopolies with ties to the 1% to control and monopolize cannabis? Will New York allow out-of-state green rush venture capitalists with pay-to-play ties to our state politicians? Or will the people of New York, who have suffered the most from the drug war, have access to the renewed New York cannabis industry? Will the average person, the person who lives in our beautiful and progressive state, be the driving force between the primary, will be the driving force and the primary beneficiaries of New York's cannabis industries? Well, hopefully that will happen. New York already has experienced the numerous problems caused by corporations who are granted monopoly control of the cannabis industry. That experience comes from the Compassionate Care Act, CCE, i.e. New York's recently created medical marijuana program. The CCA is meant to help people with ailments that can be treated with cannabis. That's a good thing. The granting of monopolies to 5 companies, expanded to 10 this year, which is what the CCA does, is a bad thing. Creating a system in which the state is divided up into territories in which companies are granted a monopoly license to control and become the sole recipient of all profits of the cannabis industry in a particular territory is and was an invitation to corruption. The crux of the issue is, who is granted a monopoly license in the territory? In 2015, the year before the CCA was to go into effect, about 40 companies bid for one of the 5 licenses. These companies had to put up about $200,000, of which $10,000 was non-refundable to the state. The starting point alone makes getting a license beyond the reach of most small businesses. Cranes, New York, May 13, 2015, reported that a small business who wanted to participate in Oregon's cannabis industry needed just $4,000 to get started. Of the about 40 companies who applied for one of the 5 licenses, it's not very clear how the 5 companies that were granted the licenses were chosen. Dennis Levy, president of the New York State Committee to Legalize Marijuana, filed a Freedom of Information Act request to find out how it was decided who got the CCA licenses. The state sent back a few heavily redacted documents that revealed nothing, stating that they were protecting trade and copyright secrets. The trade and copyright secrets were not threatened by this information. These secrets become irrelevant in a market dominated by monopoly. Besides, the public should know what they are consuming when they go to a CCA dispensary. In other words, how the process has happened should be known to the consumers. Okay. Plus, if the production processes are kept secret from the public, does that mean that the production processes are kept secret from other CCA companies? Does this mean all 5 companies have their own ways of producing the product of all that this implies? In other words, they don't let you smoke pot in the New York's current medical marijuana things. They reduce it to some kind of oil and everything, and it's highly pharmaceuticalized, technical process, when in reality it's just better off to let people smoke pot. Okay. Does this mean all the 5 companies have their own ways of producing the product and all that implies? My guess is that it's the backroom politics and who was granted a license that the state is trying to protect. The highly respected journalist, the late Wayne Barrett, reported in the New York Daily News, June 14, 2015, about Al D'Amato's lobbying firm. And he's, which has close ties to the state legislator.